Hello, everyone. It's good to be with you. I hadn't thought much about the relationship between feminism and religion until Professor Hale invited me to take part in this conference. So I'm very grateful to her for introducing me to the subject. I take religious feminism to be the attempt of feminists, both women and men, to reconcile their religious beliefs and practices with the belief that women are the equals of men, entitled to equal respect and dignity, to equality of opportunity in the political, social, economic, and cultural life of their country, to freedom from discrimination, and to equality before the law. In short, to everything that the United Nations Convention on the Elimination of All Forms of Discrimination Against Women says that the law should secure for women. Reading that convention once more, it strikes me that religion is the elephant in the room. There are nods towards the elimination of customs and practices which discriminate against women, and the elimination of stereotyped concepts of the roles of men and women at all levels of education, but nowhere is it acknowledged that religion is one of the greatest propagators of discriminatory practices and stereotypical attitudes. Yet many, nay, most of us have been brought up in one of the world's great religious faiths and would like to be able to reconcile the two. A word, therefore, about where I come from. I was brought up in, and am still a practicing member of, the Church of England. The Church of England is a notoriously flexible church. There is remarkably little doctrine, no dietary laws, and hardly any traditional practices. Yet when I was growing up, women were definitely not regarded as the equals of men. The Epistle of St. Paul to the Ephesians commanded wives to submit themselves to their husbands. Quote, "For the husband is head of the wife, even as Christ is head of the church. Therefore, as the church is subject unto Christ, so let the wives be to their husbands in everything." End quote. Thus, in the version of the marriage service in the Book of Common Prayer, the wife promised to obey and to serve her husband, as well as to love, honor, and keep him in sickness and in health. A revision in 1928 dropped the promises to obey and to serve, but both versions were still in use when I married in 1968. And of course, women couldn't become priests in the Church of England until 1994. Might I have tried to become a priest had it been possible? The church and the law have quite a lot in common. We like ceremonial, we like dressing up in archaic robes, we like the sound of our own voices, and we like poring over, analysing, and discussing our authoritative sources. These sources do, of course, present the greatest challenge to religious feminists. But the standard answer is that they have to be read in the cultural context of the time. St. Paul was a Jew who was gradually adapting to the more egalitarian message that Jesus had brought. The church should be like a constitution, as the Judicial Committee of the Privy Council said, when deciding that women were persons in the Constitution of Canada, even though it had been written in 1867. Quote, "The British North America Act planted in Canada a living tree capable of growth and expansion within its natural limits." End quote. The problem that we face is that, while some faiths, including mine, are prepared to adopt that position, many others are not. There have been several times in my judicial career when I have had to reconcile the apparently opposing forces of religious belief and feminism. Most prominent was the case of the Queen on the application of Shabina Begum against the governors of Denbigh High School in 2006. This was a school for both boys and girls aged 11 to 16. The pupils were very ethnically diverse, but a large majority were Muslims. The head teacher was of Bengali Muslim origin. She believed that school uniform played an important part in securing high standards by promoting a positive sense of communal identity. The school uniform had been carefully worked out in consultation with the local community. It included an option to wear the shalwar kameez and an Islamic headscarf in the school colours. The imams of the local mosques had approved. Shabina Begum wore this happily for 2 years until she reached the age of nearly 14. Then she wanted to wear the jilbab instead. The school refused to allow her to do so, and she refused to go to school unless it did. After she had missed more than a year of schooling, she brought proceedings claiming that the school had violated her right to manifest her religion in accordance with Article 9 of the European Convention on Human Rights. 3 of the 5 judges in the House of Lords, then the highest court in the United Kingdom, held that there had been no interference with her Article 9 rights because she had chosen to attend the school knowing full well what its uniform policy was. If she had objected, she could have gone to another school. I was one of the 2 who disagreed. It was very unlikely that she had chosen the school for herself, or that when she started there, she knew what her view of appropriately modest dress would be when she reached the age of 14. The European Court of Human Rights in Strasbourg has since agreed that there can be an interference despite the option to go somewhere else. But I agreed with the other judges that the interference was justified as a proportionate means of protecting the rights and freedoms of others. My reasons were rather different from the other judges. I had done a bit of extra reading. From this, it was clear that the knee-jerk Western response, that all elements of Islamic dress were imposed upon women to demonstrate their inferior status, was an oversimplification. There were women who deliberately chose to adopt Islamic dress, particularly the hijab, quote, as a mark of her defiant political identity and also as a way of regaining control over her body, end quote. It was a way of telling the men and the boys to treat her with respect. On the other hand, of course, there was a type of fundamentalism which used the proper behavior of women to signify the difference between those who belong and those who did not belong to the fundamentalist group, and to perpetuate the inferior status of women over the generations. So, if an adult woman freely chooses to adopt a particular dress code, it was not for others who disapprove or are even offended by it to prevent her. There is an analogy here with freedom of speech. We should not interfere merely because it causes us offence. But it was different in schools. A uniform dress code could play a part in smoothing over ethnic, social, and religious divisions. It could also help to support young women in choosing how far to adopt and how far to distance themselves from their dominant culture. The crucial evidence for me was that other Muslim girls in the school had asked it not to change the policy. They were afraid that if Shabina were allowed to wear the jilbab, they would be put under pressure by their families to do the same, even though they did not want to do so. It would mark them out from other Muslims as being adherents of an extremist group. Thus, Shabina was denied her agency in order to protect the agency of others. But of course, no one really knew whether the agency was hers or her older brother's, who'd been a prime mover in her dispute with the school. There may be other reasons why it's permissible to deny a woman the right to wear what she wishes to wear for religious reasons. In the family division of the High Court, I had to try a child care case in which the social services alleged that a young baby's serious head injuries had been caused non-accidentally by one or both of his parents. His father was a doctor from Pakistan who had come to the UK to train for membership of the Royal College of Physicians. His mother was an arts graduate from Pakistan. They had decided that she would go into full purdah while they were in the UK. That meant a jilbab, a niqab, a hijab, and a black gauze shroud covering the whole of her head and upper body. Parents are compellable witnesses in care cases, and it was essential that I heard her evidence. But we had an easy solution. Care cases are held in private. The judge was a woman. Counsel for the social services was a woman. Counsel for the child's guardian ad litem, an independent social worker appointed to safeguard the child's best interests, was a woman. The 2 counsel representing the parents were men, but it was agreed that she could give evidence screened from them, but from nobody else. Thus, the only male who could see her face was her husband, and the only people who could not see her were her own counsel. That left me in little doubt of the importance of seeing the face of a witness giving evidence. This mother's love for her children was quite apparent. So too was the fact that, from time to time, she was repeating a rehearsed script rather than giving me her true recollection of what had taken place. Other courts do not have the same easy solution. In September 2013, a male Crown Court judge was confronted by a woman defendant charged with witness intimidation, who appeared in the dock wearing a burqa and a niqab. He was concerned only about the niqab. One potential problem is identification, making sure that you have the right person in the dock. But that could be solved by a female police officer who knew the defendant, seeing her in private without her niqab, and giving evidence that she was sure that the person in the dock was the person accused. The more serious problems were whether she should be uncovered while giving evidence, so that the jury would be able to assess her credibility, and generally during the trial, so that the jury would be able to watch her reactions to what was going on when others were giving evidence, or counsel were making their submissions, or the judge was delivering his summing up. The judge ruled that she was free to wear the niqab during the trial, except while giving evidence, that she couldn't give evidence wearing the niqab, but she could give evidence behind a screen, shielding her from public view, but not from the view of the judge, jury, and counsel. He also ruled that no drawing, sketch, or other image of any kind, while her face was uncovered, could be made, disseminated, or published outside court. His conclusions are now largely reflected in the Equal Treatment Bench Book, which gives guidance to trial judges. Islamic sources agree that it is not contrary to Sharia law for a woman to uncover her face when she is giving testimony in court, or for a male magistrate or judge to look at her in order to identify who she is, to make assessments as to her credibility, where this is an issue, and to protect the rights of all concerned. But there are disadvantages to wearing a niqab in court. So how are we to know whether this is a genuinely free choice that she has made? Might she and others in her situation, like the other schoolgirls at Denby High School, be quietly relieved if the law did not allow them this choice? Someone told me that after my judgment in the child care case, when the parents were walking away from court, the mother threw off her veil and started berating her husband. So what are we to make of that? Conflicts between the dress code, which a woman or girl wishes to adopt for religious reasons, and the demands of school uniform or court proceedings may seem trivial. Much less so are the substantive conflicts between secular law and religious law, particularly in the context of family relationships, because religious law is so often predicated on an unequal relationship between the sexes. Religious feminists have sometimes turned to the secular law to help them. In the United Kingdom, along with other places, Orthodox Jewish women whose husbands refused to give them a get when they were divorced in the secular courts turned to the secular law for help. The consequences in Jewish law of refusing them a get are dire. They're not free to remarry. If they do remarry, they will be seen as adulteresses, and any children they have will be seen as illegitimate. Campaigners argued that English law recognized marriages solemnized according to the usages of the Jews as valid marriages. It was prepared to dissolve those marriages when they had irretrievably broken down, whereas religious law was not. The religious law could not be changed, whereas the secular law could. So, the argument went, the secular law should do something about the problem. But that something must not amount to coercion. The husband must give the get of his own free will. The campaign gathered strength in the 1990s when we were trying to reform the English law of divorce, so as to remove the pressure it places upon one party to allege that the other party has misbehaved. I found it all very troubling. On the one hand, the woman was placed in an intolerable situation, especially if the man was responsible for the breakdown of the marriage, yet was using the refusal of a get as a bargaining tool in the divorce settlement, or simply acting out of spite and vindictiveness. On the other hand, the problem was created by a religious law which was clearly based on the patriarchal principle that the wife was subject to her husband's rule, even a type of property. Was it not for the religious law to solve the problem? English law had abandoned the patriarchal principle long ago. Should it be pandering to it now? Moreover, if secular law moved to accommodate one religious doctrine, would there not be pressure for it to move to accommodate another? Specifically, the Christian view that, quote, those whom God hath joined together, let no man put asunder, end quote, and thus to deny divorce to anyone who had married in a Christian religious ceremony. The Church of England had adopted a more enlightened view since the 1960s, but the same might not be said of the Roman Catholic and Orthodox churches. The campaign has won. In 2002, a new provision was added to our divorce law. A divorce is granted in 2 stages: the decree nisi, a provisional unless decree, and a decree absolute, which finally brings the marriage to an end. If the couple have been married in accordance with the usages of the Jews, the court has power, once a decree nisi has been granted, to order that it shall not be made absolute until both parties agree that the necessary steps to dissolve the marriage in accordance with Jewish usage have been taken. In other words, the husband cannot get a decree absolute unless he gives the wife a get. Denying a person something he wants in order to encourage him to behave properly is not seen as forcing him to do it. But this is not much help if it is the wife who wants the divorce and he does not. However, there is a decided case where, as well as ordering the husband to pay his wife a large lump sum, the court ordered him to make periodical payments to her until he had given her a get. The court had power to do this, but would it cross the religious line into coercion? The new section had the support of the whole Jewish community. There is a provision to extend it to other prescribed religious usages where the same problem arises, but so far this has not happened. In fact, for other faith groups, in particular the Muslims, there is the reverse problem. Far from wanting secular law to accommodate their religious practices, there is a growing tendency to avoid the secular law altogether. This can happen in various ways. Sometimes the couple may be validly married in English law and so can divorce in the secular courts, but they may resort to a religious tribunal for 2 reasons. One is to have their status regularized in religious law. A Jewish woman may not be seen by her family and community as validly divorced unless she has been to the Beth Din, a Muslim woman unless she has been to a Sharia council. They may also want to have the financial consequences of their divorce decided by a religious tribunal. Frequently, however, a Muslim woman may not be validly married in English law at all, although she is validly married in the eyes of her religion. In 2015, the Law Commission noted a concern that in England and Wales, a growing number of non-Christian religious marriages were celebrated in ceremonies which were not recognised in English law. This phenomenon is not confined to Muslims, but only a small proportion of mosques in the UK are registered as places where valid marriages can take place. So the couple will have to have a separate civil ceremony if they want also to be married in the eyes of the civil law. And sometimes the couple may have been married abroad in a marriage which was valid in the place where it took place, but is not valid in the UK because it was polygamous. Curiously, in those cases, the wife may be better off than if she has gone through an unrecognised marriage ceremony here, because she could get a secular degree of nullity and the court can then make financial orders. But if a Muslim wife cannot or does not go to the secular divorce courts, she will be limited to the financial provision which is allowed her in Islamic law, usually the return or non-return of her dower. Indeed, this may sometimes be enforceable as a contract in English law. But this will be much less than she could expect from the secular divorce courts. The secular courts base their orders on a combination of need, compensation for the economic disadvantages resulting from the marriage, and the fair sharing of the assets accumulated during the marriage. Sharia councils are likely to apply their own interpretation of Sharia, which is open to different interpretations, but it appears that in England, most of them adopt a conservative or literalist interpretation, which no longer represents the law in Pakistan or Bangladesh. Our government has tended to see this as contracting out of the secular law and not, therefore, as a problem. There is a pervasive sense throughout family law that it is better for the parties to make their own arrangements than for the court to have to impose them, what we know as private ordering. If a couple are validly married in secular law, they cannot oust the jurisdiction of the divorce court by agreement. Nevertheless, the court will generally respect what they have agreed, even if it is not what the court itself would have done. If a married couple make a separation agreement or agree what the financial arrangement should be when they divorce, then the court will normally enforce these. An agreement to have another body, including an Islamic council, to decide their arrangements may be regarded in the same light as a commercial arbitration agreement, and again will normally be enforced. In a case in 2013, the judge approved the parties' desire to refer all matters to the New York Beth Din and the eventual outcome, even though the Beth Din did not apply the principles which the English court would have applied. In most situations, private ordering is a good thing, but it assumes that the parties both have a free and equal choice in the matter. This is controversial enough without the religious dimension. As Alison Diduck has argued, I worry about the marginalization of law or of some legal norms from the new framework of the family justice system in favor of only one, an impoverished and gendered understanding of autonomy. She means male-gendered. Quote, the "it's up to you" idea of justice is devoid of a theory of power and uses the sophisticated and seductive language of autonomy to return family living, and therefore family justice, to this private sphere where the risks and often realities of structural and individual inequality are not the law's concern. End quote. I said something similar in rather less academic terminology when I expressed reservations about the recognition of prenuptial agreements in a case called Radmacher and Granatino in 2010. But the problem is worse if the solution is contracted out to a religious court. The well-known feminist critique is summed up by Mairead Enright. It ignores, quote, the relational nature of marital bargaining, where couples are hemmed in by the family's particular hierarchies, expectations, duties, and orders of authority. It ignores the experiences of women who have been deliberately coerced or misled into unwanted choices of law or forum. It ignores the particular patriarchal relations of domination which often characterize religious context, and which, even in the absence of actual coercion, may limit women's bargaining power. And it ignores the impact of women's poverty on their access to justice, an impact made much worse in the UK by the withdrawal of public funding for legal services in connection with most family disputes. Enright argues that it has suited the British government to ignore all this and suggest instead a picture of responsible bargaining within a recognised contractual framework. These are good citizen Muslims to be contrasted with the dangerous outsiders who might perpetrate terrorist attacks. She makes an interesting case about the politics of all of this, but it is not for me to comment on that. I'm intrigued by her conclusion that feminists must, quote, attempt to generate a counter-discourse of legal agency to that used by the government to privatise and exclude, one which reclaims the virtues and possibilities of partial disloyalty and finds them a place within and, where necessary, outside the law. I think that by partial disloyalty, she means religious discipline. She means disloyalty to religious discipline. Can we find a way to give these women agency within our secular laws without trampling upon their religious sensibilities? These dilemmas are bad enough in my own country, where we do not have separate personal laws. They are even more acute in those countries where the personal law to which a woman is subject depends upon the religious community to which she belongs. Then the possibilities for her to turn to the secular law for relief and justice are even more limited. Thank you for listening.